All right. All right, this is State of Wisconsin versus Nicolae Miu, 2022 CF 518. Mr. Anderson and Mr. Smestad both appear for the state. Mr. Nelson is present with his client, who remains in custody. The matter is scheduled today for a final pretrial conference. We are live streaming on the Wisconsin Court's website. The camera is hanging from the ceiling. I'm the only one visible on that camera, but the microphones are live. So if you do need to have a private conversation, either push the mute button on your device or let me know so I can electronically mute it. We have a number of topics to cover. I did ask my staff to give you a list of the things that I want to cover, and then I'll address any issues that the attorneys want to bring to my attention. The first thing has to do with upcoming court matters. We do have a hearing scheduled for March 6th at 3 o'clock. That will be a date and time to review the jury questionnaires and identify individuals who are either unavailable or unsuitable to be summoned in as jurors in this matter. This is a hearing that is open to the public, but no cameras or live streaming will happen, given the nature of the hearing. I also anticipate that it's going to be relatively short. It'll simply be a matter of the attorneys and I looking through paperwork and saying jurors 1 through 10 are unavailable, so they're not going to be summoned in. Jurors 11 through 20 know somebody involved in the case, so they're not suitable, so on and so forth. We just want to identify the jurors that would be likely suitable for this case. The actual jury selection itself, where the question and answer happens, that'll be on April 1, starting at 8 o'clock in the morning. Trial dates remain on the calendar for April 1 through 12, Monday through Friday. We're scheduling from 8 a.m. to 4:30 p.m. I realize that there may be some delayed starts because the building opens at 7:45. There'll be a lot of people to get through security, so we may not be able to start at 8 o'clock every day, but it's my hope that we do so. I have put the attorneys and my own staff on notice about the possibility of court on Saturdays. That's only as an emergency. If we end up far behind schedule or if the jury is deliberating, Saturday court may be an option. My trial will be held in courtroom number 2 next door. We're moving into that courtroom because that room has some additional features that are not available in my courtroom, number 4. I ask that the attorneys contact my judicial assistant if they want to get into that courtroom in advance of trial to set up, to move your materials in, or to test out the AV equipment. I think you'll find that it is identical to what I have in courtroom 4, but you may want to check it out just to make sure. Clerk of court has reserved conference rooms for both prosecution and defense. So you can use those to huddle up with witnesses or clients and otherwise have private conversations outside of the courtroom. I anticipate that on the first day of trial, we will have jury selection the entire morning. After jury selection, we'll break for lunch. And then we will go into opening statements. Jury selection in the morning will be, there'll be a lot of people here. We're going to have upwards of 50 summons in, correct, Ms. Everson? Correct. Okay, about 50 people will be summoned in. We'll have a large panel for voir dire. We'll have another panel for reserve jurors. Those reserve jurors will be sitting in the benches in the back. So I'll have the public sitting on the opposite side, kind of how you're sitting right now. So space will be limited, so please take that into consideration for the morning. In the afternoon, the entire gallery will be open for the public. For those of you who plan to attend live, you are welcome. This is an open courtroom. I recognize many faces today. You've been here before. For those of you who have been in court before and are returning, I just want to commend you about your decorum. You all have been very appropriate in your demeanor in court. You've contributed to the dignity of these proceedings, and I just want to acknowledge that and ask that you continue with that standard. For those of you who are new, these are my expectations. Number one, cell phones have to be silenced. We can't have any distractions in court. There is no photography allowed. There is no audio or video recording allowed. There may be credentialed media. I'm going to talk about that later. They'll be the only exception, but the general public will not be allowed to record. No speaking when court is in session. My courtroom stenographer will be writing everything down, and she cannot write down multiple people talking at the same time. Also, it would be out of order for people in the audience to try to contribute to the proceedings. No outward signs of support or messages will be allowed. So no banners, signs, photographs, coordinated outfits, things of that sort. No communication whatsoever with any jurors. The jurors in this case must be free of bias and prejudice. They may not be influenced by anybody outside of the court. So no conversations whatsoever with the jurors, not even a hello will be allowed. I anticipate that there will be testimony that many of you will find unsettling. There may be visual evidence that you may find unsettling as well. If that is the case, you may get up in the middle of court and excuse yourself. I don't expect anybody to endure things that make them uncomfortable. The last expectation is to continue to be respectful. Please be respectful of the attorneys. They have a very difficult job in this case. Please be respectful of staff. We do not do trials like this every day. Please be respectful of their efforts to do as good a job as possible. And please also be respectful of each other. Any breach of these expectations or rules could result in expulsion from the courtroom or, at worst, contempt of court sanctions. I did speak with the media coordinator for the 10th Judicial District. He told me that there is media interest and the media does intend to cover this trial in one form or another. I told him that the presence of cameras, both video and still, during the trial is yet to be determined. I also told the attorneys at an earlier hearing that I wanted to get their input on the wisdom of allowing cameras in the courtroom. So with that, Mr. Anderson, what are your thoughts?
So we did discuss that with victims. Victims are largely neutral on it. Our position, on one hand, we completely understand the public's interest in this case. Our concern with cameras is the danger, the risk of improper influence on the jury. For example, somebody's spouse, friend, family member knows that they have a loved one on the jury or friend on the jury, and then they're watching parts of the trial, texting the juror, communicating with the juror. Even though the jurors are going to get instructed about what they can and can't do, doesn't mean they're not going to read a text message or a contact from somebody who may be weighing in on their thoughts on if somebody's lying, telling the truth, the significance of evidence. And then the other risk is jurors, especially if there are cameras that are covering portions of the trial where the jury is not in the courtroom. They might see that on the news, although I know they're instructed to avoid the news. So that's basically our concern, is the risk of outside influence on the jury. So for that reason, we're asking that there not be cameras.
Mr. Nelson, your thoughts?
Your Honor mentioned today we're live streaming. Is that something that's incorporated in this discussion right now, or is that something separate with the?
That is something separate. I'll tell everybody I am disinclined to continue the live streaming for trial. because I have to run it on a laptop, and I need my laptop for other tasks, and frankly, I don't want to be the cameraman in addition to being the judge. So that's probably going to stop.
Okay.
Unless there's some compelling reason I haven't thought of. But I'm talking about a television camera.
Understood. The one influences the other to some degree. If the cameras are in the, I think as we talked about, in the back of the courtroom, as opposed to any cameras in the well or facing this way, I think we'll defer to the court. I understand we don't really take a position. There's certainly Mr. Miu is respectful of the process and also looking forward to having his story told. But at the end of the day, it's important for the 14, 12 people to hear the story, not necessarily the public. So if Your Honor did do that, I think there's ways to structure it to avoid the concerns that the state had. I mean, I think some of those concerns are going to occur regardless of whether there's a camera. I mean, if a juror is going to be improperly influenced, somebody can be live tweeting it. Somebody could be doing all kinds of other things if you're a reporter that's here in the courtroom. And so there might be information out there that a person from the public could get to a juror. I think that the best way is to make sure that Your Honor, which I'm sure Your Honor will do, because I know Your Honor always has, instruct them every day about their role and their duties. And so I don't find that to be a concern regarding the cameras. I think if Your Honor did allow cameras, Your Honor could also, for the reasons Mr. Anderson stated, simply say you can't film when we're outside of the presence of the jury for the reasons that Mr. Anderson articulated, that it may be something that eventually gets back to a juror. But again, someone sitting in the courtroom listening because they have somebody and they want to put something out there, they can already do that. So that's a long way of me saying we take no position, we'll defer to Your Honor.
If cameras were going to be allowed to be one camera, one video camera, places that have been identified as suitable locations in this courtroom would be the two back corners or along the side here where the monitor is. Those would be the only three positions that I think would be reasonable. I'm not tied to those locations. That's what seems to have worked better in earlier proceedings as opposed to something here in the well or off to the side by the exit door. Mr. Anderson, Mr. Smith said, was there something else?
I guess one other thing regarding I think in speaking with Isaac's family before court, they would have concerns too about some of the more graphic things being televised.
The videos.
Video, autopsy photos.
And I agree that those, Your Honor, could certainly limit those. And I think there may be some things that, well, they're going to be shown here in court, you know, dignity of all human beings is certainly something that we support. And so if those matters are sealed, we're not going to object to that.
Obviously, there's a lot of public interest in the case, and I have to balance that interest and the public's right to know with everyone's right to a fair trial. The state's entitled to a fair trial, as is Mr. Miu. And I have to balance those sometimes conflicting interests. Give me the weekend to think about it, and I'll give you a written decision probably sometime next week. All right, anything else on that topic? Members of the courtroom?
No.
No, Judge.
All right, next topic, interpreters. I understand the state needs an interpreter for at least one witness, correct?
Three.
Three witnesses.
Yes, they're all witnesses that were with the defendant's group tubing on the river. We're trying to get our civilian witnesses done first, so likely the first, Tuesday, Wednesday, Thursday. But I know the clerk asked us, for scheduling purposes for translators. that's what I said, is that we're trying to get the civilians done first, but then I know at least one of them is on Attorney Nelson's witness list too, and then there's also the chance for rebuttal, so I don't have a great answer on specific times.
Mr. Nelson?
We don't need an interpreter, I mean, and so I don't have anything to say about the interpreter.
As luck would have it, Judge Needham will have a 5-day jury trial the same day as ours. Judge Needham's trial also involves interpreters. So that means the pool of interpreters that we usually draw from will probably be consumed in Judge Needham's trial. It may settle, of course, we don't know. But what we'll have to have, Mr. Anderson, is a date certain when we plan to call. Because we'll have to make arrangements for an interpreter to be here. We don't have them on staff, and we can't have them at our beck and call. The other problem is, if you want to have it in the first week, we may need to go out to other interpreter services to find someone available for that first week. And then that will involve time to identify somebody and time to make the arrangements. So I need to have a date certain when an interpreter will be here for that particular witness. And if we have to take somebody out of order, we can.
Sure.
But I just need to know it's going to be April X at a particular time, so that way we can have an interpreter ready to go. Yes.
Wednesday, Judge, so that would be the 3rd.
Wednesday, April 3,
Yes.
8 a.m.
Yes.
3 witnesses.
I believe it's 5. Well, I'm not sure. Some speak some English, so I'm not sure. I'll verify.
Okay. Do you plan to call, assuming all 5 need interpreters, all 5 in a row?
Yeah, I'll do them back to back from the interpreter.
Roughly how much time do you think you'll need?
I think there'll be relatively quick witnesses, so I think we could get them done in either just the morning or just the afternoon.
So you need a half day for 5 witnesses?
Yes.
Probably is going to involve 2 interpreters, Ms. Severson?
That's correct.
Because the interpreters can't interpret for lengthy periods of time without a mental break. So we'll have to make arrangements for 2 interpreters. So Ms. Severson's in the courtroom. She'll be working on making those arrangements. If there are any problems with scheduling, please let her or I know immediately so that we can look at alternatives, including alternative dates.
Judge, if I may, I appreciate the need for efficiency and not to be cumulative, but I would imagine anytime when we're talking about interpreters, we should probably double the length of time that we think it's going to take. So my suggestion is we at least book them for the full day rather than a half day. I just hate to be, at the short end of my cross-examination and we're just out of time, so to speak. So
did your half day take into account the fact that usually interpreter examinations take twice as long?
Yeah, no, that's a fair point. I think the full day is probably a better bet.
So full day for the interpreter, April 3.
Yes.
Okay. Again, please let us know if there are any changes. If you're going to call fewer witnesses, let us know so that we can make arrangements.
Okay.
All right, moving on, jury selection. Mr. Miu will get a jury of 12 persons. I will see 2 alternates, so I'll have a panel of 14. My reading of the statute allows each side 7 peremptory strikes. Do you agree, Mr. Anderson?
Yes.
Mr. Nelson?
yes, Judge.
All right. So I have 28 persons seated in the jury box, jury area. I intend to conduct the initial voir dire. You both had trials with me, so you know what I'm going to cover. I will give the attorneys time for their voir dire. If there are any voir dire questions that you prefer come from the bench, please provide those to me in advance so that I can incorporate it into my work. Now again, I'll say this for everyone's benefit, that I view voir dire's purpose to be to identify jurors that can be fair and neutral. It's not an opportunity to argue the case. It's not an opportunity to precondition the jury to your theories or your view of the facts. So please be mindful of that purpose. I ask that you respect that. As you venture into argument, or what I think is likely to lead into argument, I may poke you along to move you out of that area. I do not want the attorneys to introduce any jury instructions during their voir dire. I'm growing increasingly concerned by lawyers delivering jury instructions during voir dire, suggesting that certain outcomes should result. In my opinion, the judge is responsible for instructing the jury on points of law, so any instructions need to come from the bench. So if there is a jury instruction that you think may be something worth talking to the jury about, let me know what it is so that I can deliver it to the jury, and then that will set you up for your voir dire. I just don't want to have any misstatements of the law or any misunderstandings when the attorneys attempt to deliver jury instructions. Question?
Mr. Trofasi is going to be doing voir dire for the defense. He'll be here on Wednesday. I will do everything to articulate as accurately as I can what Your Honor just said, but I would suggest you go over that again on Wednesday.
Okay.
If I were the one doing it, my question to Your Honor would be, do I need to tell you beforehand, I'm going to ask them questions about jury instruction 140 and the burden of proof, or is that something during the question? I want to ask you some questions about jury instruction, about burden of proof. Before I do so, Judge Waterman's going to read you the instruction. How do we handle that, I guess, is something you can tell Mr. Trofasi on Wednesday, or?
I plan to deliver a version of the burden of proof and reasonable doubt. You've heard it all before. I also intend to cover self-defense, because I think that's probably going to be a theme in this case to some degree. If there are other instructions that you want me to cover or other themes you want me to cover, let me know. I don't plan on reading the entire jury instruction because I think that could be presumptive, and I think it also could be misleading. But to introduce concepts of self-defense, concept of reasonable doubt, concept of burden of proof, I'll rely on the jury instructions and the language that's used therein. So if there's something else you think I should address, I'll do that as part of my voir dire, and then you'll be able to expand on that during your own.
So we can ask questions about, the judge already read you this instruction. I just want to,
yes.
He can follow up and he just references what you've already said, essentially.
Yes.
And then we can quote what you've said.
Yes.
Okay.
Yes.
Thank you.
No personalized or individualized voir dire, except when you need to follow up on specific questions or answers. I prefer the questions be delivered to the panel as a whole, and then follow up as needed.
Does that include specific follow-up on the questionnaires?
No, what I'm talking about is the practice that I've seen with some attorneys where they want to do an individualized voir dire with each and every juror. I just prefer that you deliver the questions to the panel as a whole. I think both of you follow that practice. I just put it out there as a reminder in case you plan to deviate from your traditional practice.
I understand. The only context in which I think I've done it in the past, and I can talk to Mr. Trofasi, is sometimes we'll do, for efficiency purposes, what we call a scaled question, on a scale of 1 to 10, and then we don't ask any follow-ups. We just ask each juror, where are you on that scale, so to speak. I appreciate that that's contrary to what Your Honor just said, but I think in many ways it's more efficient than starting general and then working it down. So I'll talk to Mr. Trofasi. If we plan to do scaled questions, we might bring that up with Your Honor.
Yeah, please bring it up. And what I'm most concerned about is the practice of juror number 1. What is your name? Where do you work? What do you name your kids? What do you like to watch on TV? What do you do for recreation? Juror number 2, what is your name? What is your wife? What is your kids' names? And ask the same questions over and over again. It's just not a good use of our time.
We had all day, but I'm imagining we're gonna have limits, and I agree that's not a good use when you have limited time.
Speaking of time, I am inclined to impose time limits on voir dire. I have a number in mind, but I want to hear what your thoughts are as far as time limits and how much time you'll need. Part of it has to do with the fact that you have the supplemental questionnaires, which answer probably a lot of information that you normally ask during the voir dire. And of course, there are going to be areas that you'll have to follow up on, but I think a limited amount of time is reasonable. So, Mr. Anderson, thoughts on time limits?
45 minutes.
Mr. Lawson?
I was gonna request 75.
The number I had in my mind was 60, so right in the middle. So 1 hour for each side. Of course, if there is a reason to expand that, just let me know, and I'd be happy to take that into account. Opening statements. Again, I'm thinking time limits would be appropriate here as well. It's worked well in the past because I think it helps to narrow the focus of the statements and to keep the jurors' attention. Mr. Anderson, thoughts on limits, and if so, how long?
I'd say same as my last answer, 45 minutes.
Mr. Nelson?
I think 75 makes me the most comfortable, but I can certainly live with 60. I've done
The
it.
number I had in mind, 60. Do you intend to deliver your opening statement immediately after the states?
Yes, Judge.
Okay. You may use exhibits during your opening statement only with consent of the opposing party or my permission. I just don't want to have any exhibits used in opening statements that may be inadmissible during the trial. So please either get agreement of your opposing counsel or my approval before you attempt to use an exhibit in opening statement.
Why don't you discuss that now, or have a discussion after the record before we come and talk to your honor?
I wasn't planning on doing it now. So have you talked about exhibits during opening statements?
No, I'll just say that my plan would be to use some of the still frames from the video. I don't plan, there's like 4,800 still frames. I hope to limit it to 10 or 20 that gets it into that, right? I would imagine neither of us can or should play the video itself in the opening. But as I sit here right now, that's my plan. Maybe Mr. Anderson and I can talk about it later, perhaps a map, or there's some other general photos.
Mr. Anderson, were you planning to use exhibits?
I was thinking the same thing, some of the stills.
Okay.
So I imagine we'll be able to come to an agreement.
Yeah, please talk with each other, identify those that you want to use. If there's a disagreement, bring it to my attention, I'll make it. Sure. All right, anything else about opening statements that you think I overlooked?
No.
Trial procedures, I allow 2 rounds of examination. I have some compelling circumstance to go beyond that. I also allow only 1 attorney per side to conduct the examination and make the objections. So please organize your witness schedule accordingly. I do not allow objections to be argued in front of the jury. You may state the grounds for the objection. For example, objection relevance, objection hearsay. But if you want to make a robust argument, please approach the bench. If you want to develop a record, let me know and we can excuse the jury so that you can make that record. Any conversations at the sidebar are not taken down by the court reporter. So bear that in mind. If you want a record, we need to excuse the jury or remember to do it at one of the breaks.
And I understand we're going to be in a room where DAR is typically done. And I know in the past when I've had trials there, sidebar conversations are picked up by DAR, but that will not be the case in this trial because we won't have a DAR court reporter.
Correct.
Okay. I don't have a preference for DAR.
Any motions that you want to make, again, please do that outside the presence of the jury. If you can approach and let me know that you've got a motion or give me some signal, I'll happily give you the leave to make that motion. I do want all exhibits to be pre-marked, state using number 1 through 100. Will that be enough exhibits?
I don't think so. I guess it depends on how, because all the civilians, for example, that were interviewed, there's generally body cam of those interviews. I don't intend on admitting them all. I don't think they'd be admissible unless it's either admitted as a prior inconsistent or prior consistent statement. I could make flash drives of all of them and pre-mark them. Or what my plan was to have them all available, but only mark them if and when they became needed. So I don't know if you have a position on that.
That makes sense to me, just as somebody who's going to be cross-examining these witnesses and having lots of recordings available. I could absolutely have a list of all of those exhibits, but it's inevitable that, then the exhibit list is going to be 1, 3, and 7. I mean, it's not gonna flow like it's normally. Maybe that's an inconvenience we can all sort out, but.
So, Mr. Anderson, are you proposing to put all of the videos on one single flash drive for use during the trial?
I could do that, or I could do separate. If separate, it's all, because, some were interviewed at the river, again at the hospital. Some were just interviewed after, so there's a lot of video of interviews.
Which may or may not be used.
Correct.
Agreed. That's if they say what we think they're going to say, there's not going to be the need to impeach people, so to speak. So
I think maybe what would be simplest is those ones that I don't see will for sure be used, but could be depending on how the trial goes. Put them all on one high capacity flash drive, and then have them well labeled. And then perhaps we just, the two of us come up with a list starting at 400 of all of these recordings, and then no matter which one of us use it, we just reference for it. It's not the state's number or the defense number, it's just, these witness recorded statements. I don't know. My preference is not to have it on some, I have them all already, right? I don't need an extra copy. I worry sometimes if we put a whole bunch of stuff on one exhibit, it's not always clear what digital things on that exhibit have been or have not been admitted. Obviously, we can do a better job about making our words clear, but sometimes just the physical object having one thing on it makes it easier.
How many separate interviews were there?
I have on my disk, I know that there's 154, and that doesn't include like the video of the incident or the second video of the incident or something. So there's maybe 200. I know there's over 150.
Speaking only for myself, and I think the clerk would share this sentiment, we don't want 200 flash drives floating around. It just sounds like a recipe for something getting lost, or a flash drive getting corrupted, or mislabeled. Let's just put this thought on hold. Maybe talk with Ms. Severson, try to find a way that you can have this information available as an exhibit if you need it, but it's not going to be so voluminous that it has the potential for mishaps. And then we can come back to the marking of the exhibits maybe at a later date. We'll figure that out.
Okay.
But I would like to have whatever numbering system we settle on, pre-marked exhibits with an exhibit list of the general format file of the GF file given to the clerk on the day of trial. So that way she doesn't have to try to create it on the fly as we go.
Just so of, I mentioned 100, I expect 10% of those videos, if I was gonna take a guess, it's gonna be more like 15, but there's a potential certainly for the 150 to 200. I don't want to scare anybody.
I'm thinking if you put it on one device, one flash drive, one CD, whatever, you could label it number 1 and have the interview identified, number 2, interview identified. That might help you to keep it organized.
Another idea is we have one with all of them, so like when it becomes necessary to use it mid-testimony, we have it readily available, and then we can also do an individual flash drive with that one that's admitted.
Well, let's continue to brainstorm on this topic.
It might be something we change on Wednesday, right? It might be something that we have a plan and then we think something better when we're in the middle of it.
Trial schedule, obviously the jurors are going to be making a huge sacrifice. We're setting aside 2 weeks for trial. It's a big sacrifice for them. In return for their sacrifice, I just expect the attorneys to be on time. Please have your witnesses ready to go. Use the time efficiently, stay organized, avoid repetitive questions, avoid cumulative evidence. I'd like to maximize the day as much as possible. So please have witnesses available from 8 a.m. to 4:30.
Day 1, we're gonna have witnesses come at 1 p.m. on Monday.
We'll probably be starting opening statements then.
Yeah.
So your first witness probably won't be called at the earliest until 3.
And that's, in my opinion, extremely optimistic. I appreciate everyone's optimism, but
yeah,
I'll probably do 2 p.m. just to be safe.
Judge, regarding that trial schedule, I know courtroom opens at 7:45. There's lots of people that want to be in here. There's lots of those people that I'm sure have emotional, appropriate emotions. I want to make sure that I get in here on time, right? And I'm selfishly worried about my own ability to get here, and I'm worried about contact with other people outside while we're all waiting in line. I'm worried about contact with jurors while we're all out there waiting in line. If there's some way we can start earlier, I'm not looking for a pass, but I'm just, if I get stuck in line I rarely want to be treated special, but I'm worried about my being in here at 8 o'clock if there's only 15 minutes to get through security. And I think security in this case for my client is extremely important.
Or we can't start without you.
I know, but I don't want to be late. So I'm just throw that out there.
Yeah,
somebody smarter than me has a solution.
Yeah, I'll talk with staff and see if we can find something that addresses that concern.
Appreciate that.
All right. I believe that covers the list of trial management topics I wanted to address. I plan to move into motions and limine unless each of the attorneys have matters they want to bring to my attention.
Can we just go back to the interpreter? Victim witness raised a good point. If we could do Friday, April 5 instead of that Wednesday.
Friday, April 5?
Yes.
All right, let's talk about motions in limine. A number of motions were filed. Let's take them one at a time. Document number 321 filed by Mr. Nelson. He asks to exclude the Juwan Cockfield video after 2 minutes, 25 seconds, or in the alternative, mute the audio after that moment. I haven't seen that video, obviously, so you'll have to tell me what the basis is.
Judge, if you would be willing to reserve on that, because I think it seems silly to me for 2 people to be here describing it. Just the video is the video. That picture's worth 1,000 words, right? I think Your Honor needs to see it. If it's not played in the opening, that might be something that we have some time to sort out between now and then. I don't plan to make a stand on my written motion. Essentially, it's the probative value is outweighed by the unfair prejudice in it. That's my concern. I appreciate Mr. Anderson wrote a response in there. It may be something that, if Your Honor denies my motion, I bring it up if it's played a second or a third or a fourth time, depends on how many times it gets played. And so that's all I have on that today.
Mr. Anderson?
I agree. I don't know how Your Honor can rule on it without seeing it, because a lot of it is I don't think we could ever adequately describe it. I have it on flash drive. I could file it under seal. I think both sides definitely do not want it to get out to the public and potentially a jury pool prior to trial.
You plan to play it during your opening statement?
No.
Okay.
I would prefer a ruling on it sooner than later, just because if the court does grant it, I want to have an edited video, whether that's muting after 225 or cutting that out, because then I want to run the risk of not hitting pause fast enough or mute fast enough and violating the court's order if the court does agree with defense.
How long will it take you to edit it?
I think we have software that will work for it. Well, access to software, probably about an hour. I know the sheriff's office has done it before for us, like when things have to be bleeped out.
When do you anticipate playing it?
Probably right away in the trial.
Day one, correct, potentially?
Yes, because I imagine there's going to be questions from both sides of witnesses about stuff that's in the video.
And while I appreciate the state's, as they should, as we all should, wanting to make sure that whatever the court's order is, it abide by. I put 225. If Your Honor rules it's 227, or I mean, there's a point in the video when there's no more information related to counts 1 through 6 directly, right? I mean, the video shows some of those alleged acts on the video, but clearly it's all over by 225 when it relates directly to that. There might be some other things, and I appreciate their argument, but I say that because whether it's paused at 220 or 225 or 226 or 227, I don't think is really, it's the overall, a whole minute of the yelling and screaming.
There's one more argument I have on it that I neglected to put in my response, and that's that both defendants group of tubers and an additional group of tubers that will be witnesses from both those groups at trial, at all the way up till the end of the video. You can see where they are and where people in those groups are standing on their tubes. When it comes to like ability to see what they thought they saw, that kind of thing, you can actually see where they are in relation to where the incident happened.
And then lastly, Judge, just my biggest concern regarding the visual aspect of it is, and I apologize here, just that there is, the water turns red in a certain area. I mean, that's my biggest concern. And in the close-up of, I believe it's A.J. Martin, who survives of his injury, the audio is my biggest concern. Is the person who's making the video, goes through audibly their emotional states and is narrating things that. So you'll have to watch it, but if I say that because there might be a way around it to say either that portion of the video is described and agreed to what those facts are related to people's positioning, or as I said in the alternative, it's played without the audio portion of it.
Here's what I'm going to do. It sounds like both of you agree that the video is going to come in some form or fashion.
Yes.
As far as your editing issues, Mr. Anderson, you know that the objection is after 2 minutes, 25 seconds. So either the entire video after that moment is going to be not played, or it's going to be muted. So those are your editing options. And you can prepare in advance videos that meet each one of those potential rulings. I'd like to have this video presented to me the morning of trial. It'll be marked as an exhibit. That way I can identify it as exhibit number X. So we'll have a nice clean record. I can review the video since it sounds like it's relatively short. Sometime that day during one of the breaks, probably over lunch, and I'll be able to give you a ruling. But that way I think it protects your concern about the video being leaked out to the public before it should, and potentially prejudicing juror members. But it also allows a ruling after I've had an opportunity to look at the video and determine from my own eyes what it is objection. Does that make sense?
Yes.
Totally understand it, Your Honor. I just would add, I've watched that video probably 1,000 times, and it may have taken me 100 times to kind of parse out exactly, and you'll get the benefit of perhaps people who've watched it 1,000 times talking about it in their opening, or at some time to put it into context, but it's not easily digestible on its first watch.
It's panning around quite a bit, and
There's a lot going on.
I agree. I probably watched it on slow motion dozens of times.
I'm going to watch it the way the jury would watch it, which is continuous.
I think both of us, we have the video broken down frame by frame. And we also have, on a player, you can just click to go frame by frame. So I think both of us intend on doing that type of thing at trial.
But not after 225.
Yes.
Okay.
For example, there's a nurse and her husband who came to the aid afterwards, and you can see their groups of tubes, but if you just play the video full speed, you never see it because it's panning all around. You have to really slow it down.
If you don't think I can watch the video during a break, day one of trial?
I think you can. I just
digest it.
Sorry. I think you can. I think but maybe I'm jumping ahead here. I heard Your Honor say you plan to give a preliminary instruction about self-defense. So not knowing that, my plan was to send a letter to Your Honor with an offer of proof to say, here's why I think Your Honor needs to do preliminary instruction on self-defense. And I was going to give the defense offer of proof regarding the video, including 40 of those frames, right? And so obviously the state can do their own offer of proof, but if that's just to the court beforehand, we can both provide Your Honor with an offer of proof as to what we think the video shows and why it's important. That might help Your Honor's analysis. I'm already halfway through with mine. I don't know if the state wants to do that. Maybe I'll do, if I can do mine by Wednesday, I'll do mine by Wednesday. And if Mr. Anderson wants to respond or do something different, he can afterwards. I'd suggest that be sealed, and then Your Honor can decide what to read or what not to read before watching the video.
So we're talking about what instruction now?
No, I'm saying I was going to give an offer of proof to convince the judge to give a preliminary instruction on self-defense. I heard the judge say that he's going to do that.
Going to screen it during voir dire, and say I'm going to give a preliminary instruction.
Okay, well, so I'll still do that. I apologize that I missed. So my plan is to send the judge a letter to say, I think you should, in your preliminary instructions that you read a portion of 805, and I'm going to make an offer of proof that was going to include the video, but maybe I don't do that for the reasons Your Honor suggested, and I just do a written version with some of the frames that, I'm trying to do it in as factually neutral way as possible with the verbs. But that's what I plan to do, and so maybe once Your Honor gets that regarding the preliminary jury instructions, we can then begin discuss when, if at all, Your Honor watches the video. Because Your Honor might need to watch the video to make the decision about a preliminary instruction about self-defense.
The other thing that might help is the frame by frame PDFs, because we could probably agree on which frame is 225 and after, if it helps on that ruling.
All right, let's do this then. Change of course. Mr. Nelson, present your offer of proof. That's going to be more expansive than just the issue about the video. Include the video, include whatever else you think I need to see. I'll review it under seal so that it is not released to the public and potentially taint the jury pool in advance of the trial. Mr. Anderson, if there is anything that you want to put in writing in response to that, in addition, you may wish to submit additional frames or other evidence that you think is pertinent, please do so. And then I'll have a decision ready by day one of the trial.
Okay, and I'll plan to hand deliver that on Wednesday at 3 o'clock, so then we don't have to worry about it. You can make your decision about the sealing right then and there.
Oh, very good. Mr. Anderson, you'll get your response a week after.
Okay.
All right, moving on. Document number 286, defense motion to exclude expert testimony outside the scope of the state's disclosure. Was there something specific that you were concerned about, Mr. Nelson, or was this a motion to avert any misunderstandings?
A motion to avert any misunderstandings in the state's filing number 279, number 14, they list their 3 experts. And so I think at the time that I filed mine, maybe I did already have that. I didn't read it as close as I should, but they've narrowed down that. So as long as it's those 3 experts, I think we're all on the same understanding, and anything beyond those 3 experts, we need to have a separate hearing or ruling about.
So I'll just reserve on the motion. I understand the concept you're raising, but I won't make any anticipatory rulings in the absence of any specific facts or specific objection. If something comes up, make an objection, I'll make a ruling. Next, I have document number 279. State filed multiple motions in limine. Many of those motions are very familiar and appear to be anticipatory in nature. There are a couple that I want to address specifically. One is paragraph number 3, the request to sequester witnesses. That motion is granted. I will sequester witnesses. I direct both attorneys to advise all of your witnesses about the sequestration order. They may not sit in during any portion of the trial. They may not discuss their anticipated testimony or completed testimony with another witness. So please admonish all of your witnesses about this ruling. I will allow an exception to the sequestration for a court officer. The evidence, you may do so. Obviously, Mr. Miu will be here to assist Mr. Nelson and Mr. Chiropoulos.
Can I get clarification? What I heard you say, Your Honor, was can't discuss their testimony or anticipated testimony. I just want clarification what you meant by anticipated testimony. My understanding generally of sequestration is anyone who's testified, they can't talk to any other witnesses about what happened in the courtroom. Witnesses who have already testified or are yet to testify.
Right, so I don't want witnesses who are yet to testify to say to another witness who is yet to testify, here's what I'm going to say. That would be a breach of the sequestration order. I see that as witnesses getting their facts straight.
Sure.
So they shouldn't be talking with each other about what they plan on testifying about.
Yeah.
Imagine that's fair game, this cross-examination to ask whether or not they've complied with that court order, because I know at least some of the state's witnesses live in the same house as each other. And I understand, and again, I'm not, up until now, when Your Honor had the court order, this was what I'm sure they would consider a traumatic experience, and I'm sure they've shared it with each other. And so it's, but things as of today, March 1st, that's different.
I suppose the devil's in the details. I just don't think it is appropriate for witnesses to talk about what they are going to say in the courtroom.
So
Because then I think it just leads to the question about whether or not their testimony is going to be tainted, or they're trying to taint somebody else's testimony by having two witnesses compare notes and get on the same page. I don't know if there are going to be situations where witnesses may be tempted to do so, but I make this as a blanket sequestration order in all my cases, because I don't want witnesses comparing notes and bending their testimony to fit a certain situation. I think that's inappropriate.
I agree, and we do. So we've already started meeting with witnesses, and we tell them about sequestration. We also tell them that, you might get asked about who you talked to about this by defense. Don't collaborate or come up. We give them that admonition.
It sounds like we're on the same page. And if there's questions about breach of that sequestration order, it may be grounds for cross-examination. It may be nothing to worry about, or maybe significant. It just depends on what happened. So just tell witnesses, don't talk about your anticipated testimony with anybody else. Keep it private. That doesn't bar the attorneys from working with their witnesses and preparing them. But witnesses shouldn't be comparing notes of their anticipated testimony with other witnesses.
The only other follow-up on number 3, judges, there's a sentence in there that the state was opening statement is not part of the sequestration order. I know that different judges in different trials in this county have had different interpretations. So I just want to make sure that we know what the rule is. I can't recall if Your Honor, you didn't say no, you said number 3 is granted. So my position would be number 3 should be granted, but it should include barring speaking to witnesses about opening statements.
Mr. Anderson?
The sequestration generally is just for testimony. The court has discretion to include opening statements. Frankly, I researched this because one time I had a trial where it was unclear what was ordered regarding opening statements, and then I told the analyst, based on opening statements, you gotta call a babysitter because you're gonna be here a while on cross, and it became a big issue. The point of sequestration, I think, is all about testimony, not about what somebody argues in an opening.
Hopefully nobody's arguing anything in an opening.
Sure, summarizing it in an opening.
Yes. I will extend sequestration to openings, because what the attorneys will be doing is saying, witness 1 is going to say this, witness 2 is going to say that, and that sidesteps the sequestration order.
One more thing on that point, Judge.
I think I know what you're going to say.
Okay.
Victims are exempt from the sequestration order. They have a statutory and constitutional right to be present during all court proceedings, and I will grant that exception. Yes.
No objection to that, not that it mattered, but they're still subject to the sequestration order portion that says they can't talk about their testimony with other people, though. Agreed?
Correct.
Okay. So they're not completely exempt from this order. They're just allowed to be present in the courtroom.
Good point. Yes.
One last point. I know it's a little unusual, but the state is requesting 2 court officers. One of the reasons is we have so many.
That's fine.
Okay, thank you.
All right, let's move on to paragraph 14, testimony from doctors Froloff and Meyer and the DNA analyst Amber Lind. I was unclear exactly what you were asking, Mr. Nelson, or Mr. Anderson.
Regarding Dr. Froloff and.
Well, all of it. What's the concern?
I was just, it's basically putting on notice that these are my experts.
Okay.
We have not filed a Daubert motion and do not intend to.
But of course, witnesses will have to have foundation for what they say, including experts. So I'll wait for that foundation and entertain any objections that may arise. Paragraph 16, potential claim of imputed conflict of interest. What does this motion pertain to?
So I think it's essentially not an issue, but I just want to make sure that on appeal it's not an issue. So Attorney Nelson's firm represented who will be one of our court officers in what resulted in a traffic conviction. My understanding from Attorney Nelson is it's not a conflict as to that investigator, because that investigator specifically for this reason waived any conflict so that Attorney Nelson can be defense on any cases that investigator's on. I just want to make sure that the defendant knows about that, and so there's not an appeal where he says, had I known this, I don't think my attorney, I think my attorney was conflicted. I wouldn't have wanted him on my case. So I guess I'm just looking for a question or two from the court to the defendant. Are you aware of it? Are you good with Attorney Nelson being your attorney?
Mr. Nelson.
I object. It's not a conflict. It's not Mr. Miu's conflict. I think colloquy with my client in any way that may potentially undermine my relationship with my client. I know it's not your Honor's suggestion, it's the state's suggestion. It's a slippery slope that there's no reason to put a toe on that slope. There's no conflict. My firm's prior representation of a witness in this case, if that witness wanted to raise a conflict, that witness could raise that conflict. That person, call him JS, has not come forward and raised that conflict. That person, if they did come forward, I would produce a waiver of that if they did raise that conflict, I would produce a written waiver of that conflict. It's not an issue.
Your firm's representation of JS is unrelated to Mr. Miu's case?
Correct. It's done, dusted, the appeal's over. It was over before Mr. Miu was arrested.
The incident, I think, was over 5 years ago already.
JS incident was 5 years ago, case is closed, represented by someone in Mr. Nelson's firm. Now,
That's
Mr.
me,
Nelson,
represented by the firm, which includes me, obviously. I was not the lead attorney.
is there a substantial relationship between the JS case and Mr. Miu's case, Mr. Nelson?
No.
But what's the conflict of interest that you see?
So can we go to another bullet point or another, it's kind of relates to another one of my motions in limiting. Find it. So paragraph number 5. So generally,
If it's helpful, we agree and won't object to or granting number 5.
How does 5 relate to 14, correction, 16?
just because generally the only questions of a witness regarding absent another acts motion is, do you have any criminal convictions? If it's yes, how many? For JS, the answer is 0, but then there is the potential of specific instances of being able to be cross-examined on, and that's what I reference in number 5. And theoretically, a defense attorney could try to, under the statutes cited in paragraph 5, bring up the traffic offense. I don't think, it's never been raised by a defense attorney before in 5 years. We've always disclosed it. It's never been raised.
Maybe what I'll do right now is I'll reserve on 16 Mr. Nelson, if you haven't already, would you please have a conversation with your client about what this all involves, so that he's at least informed about the situation and knows what we're talking about. That way, he has transparency and full disclosure. If there's anything that I need to get involved with, I will. But at this moment, I don't see that there's a conflict of interest under the rules of professional conduct, because one matter did not substantially relate to another matter, and it involved a different attorney in the same firm. There might be an imputed conduct or imputed conflict, of course, but these matters are not substantially related. But I think in fairness, maybe disclosure would be appropriate.
And Judge, with the permission of Mr. Miu, who just gave me permission, I can tell Your Honor, as an officer of the court, I've already done that, so I don't intend to do that again, but I can tell you as an officer of the court that I have done what Your Honor just ordered me to do. Thank you.
I'm satisfied, Judge. I just wanted to make sure we, addressed it, so.
Mr. Anderson, are there any other paragraphs that you think are deserving of a ruling this moment?
Attorney Nelson said he has no objection to paragraph 5. I don't think Your Honor specifically ruled on it. I'd ask that that be granted.
Okay, that objection 5 is granted.
I think number 2, I ask that that be granted. I don't know what the argument's going to be, but it's not a two-phase trial.
But what I gather from most of these motions is follow the rules.
Sure.
These are all rule-based motions. And I expect everyone to follow the rules, whether or not it's raised in a motion. So if there's something specific that I can make a ruling on, something that is right for determination, I'm happy to do so. If it's only about trying to head off problems in the future, I think you've done that by identifying certain points, and you've brought the law to my attention. But absent specific facts, I'd be making decisions in the abstract, which I'm not capable of doing.
That's fine, then. I think we've covered the state's now, Judge.
Okay, so I'll reserve on the balance of the state's motion and ruling. If anything comes up, make an objection, I'll make a ruling.
In regard to number 2, and maybe we talk about this more, I understand and appreciate this, the State v. Flatham and the state's position. My concern is that, for lack of a better phrase, it's good for the goose, it's good for the gander, meaning if it's excluded for the goose, it should be excluded for the gander, and that is there should not be fact witnesses that the state calls that get to make comments about my client's mental health, because there's terms used that they use to describe him that I understand are in a colloquial sense, not a clinical sense, but they use terms that refer to my client's alleged mental state. As far as, just again, I apologize, I don't want you, but crazy, right? And so maybe we get into it later and we do something more, but if the state puts on witnesses who essentially get up and say, my client has a particular mental state, not intentional or not mean, but mental state in the sense of mental health, that might open the door for us to rebut that. And so that's why I just mentioned it for those reasons.
Again, I can't judge something in the abstract. I have to wait and hear what the facts are. So if something comes up where I need to make an objection and step into this subject matter, I will. But at this moment, it doesn't sound like you have anything specific for me to rule on. So I'll defer it until trial when something happens. All right. Document 325. There's a recent filing about character witnesses that the defense identified on its witness list. Mr. Anderson wants an evidentiary offer of proof.
Judge, can we, I apologize, I appreciate that you put it in writing. I got this last night. I had hearings this morning. I have not had a chance to research this, what he put in there. Is this something we can bump down the road till Wednesday so that I have a chance to read it? But in regard to that, I think how I analyze it are, I guess, three things. One is, do we need to make an offer of proof? Two is then, when do we make that offer of proof? And the third part is, the defense would like to know if we do enter into evidence regarding my client's character for peacefulness, and Your Honor does allow the state to rebut that, there has not been a motion to admit other acts. There are, in my review of the discovery, 3 potential matters that maybe fall under other acts or rebuttal. And so before we make the decision about whether we're going to introduce witnesses regarding my client's character for peacefulness, I think we need to know the ruling on what can they use in rebuttal, and does the state intend to not only use what they put in their motion, but I think there was mention by some witness who's no longer on their witness list about some alleged incident on some river in Minnesota in July, in which they claim it's Mr. Miu.
We're not getting into that.
Okay, that's good, thank you. And then I think in the discovery, there was some investigation in which they interviewed or talked to people about my client's relationship with his ex-wife, not his current wife who was on the river with him, but a previous wife. And I think, you know, that sometimes happens, ex-wives said some things that were unflattering of my client. And I don't know if that's going to be used in rebuttal to character for peacefulness or not.
I believe that's proper rebuttal evidence. If she has an opinion as to his reputation, that we were allowed to rebut reputation evidence with other witnesses who have an opinion on somebody's reputation. And on cross, we can get into specific instances. So Attorney Nelson's witnesses, we can cross-examine them. Are you, do you still have that opinion? And I cited to a case where
I appreciate that. I just wanted to know whether they're going to do that. And so he's given me the notice that I was seeking. I think we can analyze it then later once I've had a chance. So I appreciate the notice.
So let's defer on document 325, so allow Mr. Nelson to review it. I did read the Jackson case. The proffer there, at least according to my reading, was related to preserving an issue for appeal. So please take a look at that. If I'm wrong, let me know, but I'm almost positive that was what the proffer was about, not a precondition to admissibility.
okay.
But if I'm wrong, you'll let me know. Right,
Yeah.
so 325 is on hold. I had trial briefs, documents 283, 285. I read those. I take them for informational purposes only. No decision is required now unless somebody draws my attention to something.
What numbers were those, Judge?
Document 283, 285. I think they were both yours.
Okay. All right.
Are there any other outstanding motions that need rulings?
No motions, Judge. I do have some matters I'd like to bring up. I don't consider them motions.
Any motions, Mr. Anderson?
We provided no motions, I guess, on more matters.
Okay. I want to also acknowledge the jury instructions that you both have requested. I know that there is a disagreement about jury instruction 140 and the self-defense instructions. We're not going to solve that until we hear the evidence. So those will be reserved until the instruction conference. I appreciate notifying me about where the fault lines lie so that I can. That concludes my list. Mr. Anderson, what's the matter you wanted to address?
Two things. I know that Your Honor, when we were provided with the jury questionnaires, you ordered that they not be disseminated outside of our office. I just want a clarification on that. I'm hoping the two who are going to be our court officers can assist in wanting people to make sure they're not felons, live in the county, etc. We can keep them in our office, but I don't even want to show them to them without getting Your Honor's permission.
That is acceptable.
Okay.
I want them kept in your office, but if your investigators need to look at it to verify criminal backgrounds, that's fine. Same thing, Mr. Nelson, if you have support staff that are assisting you in preparing the trial, they may view the questionnaires too.
Sure. And I I understand the questionnaires. That does, of course, doesn't prevent us from doing whatever research we want or asking about, Joe Smith is on the questionnaire, and I know he works at Burger King in Hudson, and I know somebody who works at Burger King in Hudson. I could certainly ask that other person, tell me what you know about Joe Smith. I don't see any reason that I couldn't do that. I just want to make sure. I rarely ask for permission when it's not been told I can't, but I'm very sensitive to these matters.
That has nothing to do with the jury questionnaire, but you're running awfully close to potentially influencing a juror or speaking to a juror. These people are potentially going to be summoned in, and if there is a conduit of communications, it's running up close to some prohibited areas. So,
Understood. They can choose who I ask. I understand that. Okay.
other matters, Mr. Anderson?
So we've run criminal histories on all the witnesses. I don't know if Your Honor wants to rule now on what the number will be if asked, if you want Attorney Nelson and I to see if we can agree on what those should be before and take it up next week.
I prefer that you both see if you can agree on the convictions.
Okay.
And then we'll circle back next week.
Okay.
Yeah, and I just got them, so I will do
Yeah.
everything I can to get an answer by. Yes, Judge. One of the state's motion in limine involved us not introducing evidence of our client's statements. I understand and appreciate that. Nevertheless, there's a recorded interview of him with investigator Brandy Hart. I just ask that if the state's going to play only portions of that as opposed to the entire, that they give us notice of that so that we can begin our analysis of the rule of completeness and what other portions of that are. For now, I'm going with the presumption that Your Honor denied our motion to suppress, so the state's going to play the entire motion. But rule of completeness means we might be able to introduce some of that.
Mr. Anderson?
That actually brings up a good point regarding, there's one motion in limine I do need a ruling on. It's the one about not admitting evidence of the absence of prior bad acts. So I think at this point, what our intention is to play the whole interview, except mute the part where he talks about never being in trouble before, because that's inadmissible.
That's his using in layman's terms that he has a character for peacefulness. I mean, I don't see a major distinction between him saying I've never been violent before and him saying I've never been in trouble before. I mean,
It's essentially saying he has no criminal history. We're not allowed to bolster witnesses or talk about anybody's lack of criminal history.
Does he have a criminal history?
No.
my worry is that the muting of it or the cutting of it, is likely to be implied in a negative sense that we got something suppressed. And I don't want that in any way. I know he's not going to say that, but I mean, I think that's the general, if something's kept out, I think the general public would think it's because Miu's attorneys kept it out. And that's a negative inference. Even I appreciate that we instruct them, but just I don't see the basis to keep it out, and I'm also worried about that, what that implies.
Your plan is we started this conversation by what portions of the video is going to play. You intend to play the entire video, with the exception of this one area.
Yes, I want to watch it one more time before I decide for sure, or probably a couple more times, but I think that's the plan, yes. If
that changes, notify Mr. Nelson so that he can identify portions that he wants played, or if there's a rule of completeness issue. As far as Mr. Miu saying I've never been in trouble before, I'm going to allow that to be played. I don't see that as somebody saying there was no criminal conviction or criminal history. we admit criminal convictions because criminal convictions tend to, for right or wrong, indicate someone is less credible. And the rule about admitting the absence of criminal convictions is to prevent someone from taking the wrong inference that people without criminal convictions are more credible. Somebody just saying I've never been in trouble before doesn't necessarily imply the existence of criminal convictions. It's a general statement. I think it's relatively harmless. It's not going to be used in argument, certainly, to suggest, well, since he's never been in trouble before, he couldn't possibly have committed this crime. And that would be a false, fallacious argument. So,
Or that he has a character for peacefulness because of that.
Character of peacefulness is a specific.
Yeah, you'll have to present character evidence if that's what you want the jury to know, character for peacefulness. The video, him saying I've never been in trouble before, doesn't suggest peacefulness.
Understood.
So the video will be played in its entirety, including never being in trouble before. Character evidence is something different. You'll have to present evidence with sufficient foundation. On this topic, please talk with one another about what videos you do plan on playing, because what I don't want to have happen is the state choosing to play video X, and there may be objectionable portions on video X that I need to review. About what videos you intend to play, so that if there are objections, they can be brought to me in advance, so I can screen the objection, the portions that you have an objection to, and make rulings.
Yeah, in relate to only 2 videos of Mr. Miu, your Honor's already made rulings on.
Okay.
Except for, which is the next part, there's all kinds of, as your Honor knows, jail calls are now video calls. Those are recorded. We've got hours and hours and hours of those, as well as, thousands of pages of texts back and forth. I'd ask that your Honor ordered that the state give us notice if they intend to use any particular portions of those jail calls or texts, rather than us go on some sort of hunting mission to figure out what, if anything, are they going to play. Just seeking notice, that's all I want.
Mr. Anderson?
I object to that. Defense has them. If defendant testifies and he says, I don't think we should have to put him on notice of the kind of tough questions he might have to answer based on what he said in recordings, so he can plan his testimony around it. That's part of cross-examination that we don't have to outline the.
Is there anything that you intend to use as part of your case in chief?
I don't think so.
Are there any statements on these calls that are probative?
There are statements about the incident. There are statements where he talks about the incident.
How many?
A decent amount.
You have them.
And
Again, simple answer is yes. I mean, my hedging paranoid criminal defense lawyer is, I have some, I never know if I have everything, right? And so yes, I definitely have lots of recorded calls that he made from the jail and lots of texts that he made from the jail. It's, to be honest, I think the videos it's the texts. There's like thousands and thousands and thousands of pages within the texts. And sometimes those are just harder to, maybe I just need to read thousands and thousands and thousands of pages of text, but.
I'm not going to make a requirement that the state disclose, because I think each side has an obligation to prepare your own case, and there's not reciprocal duties to outline the trial strategy or the approach. But I will say this, I don't want surprises during the trial. I don't want to be sitting out here while the jury's in the back, twiddling their thumbs while we sort out text messages. So, Mr. Anderson, you don't have to identify them, but if there's an objection, I can't promise I'm going to give you a ruling on the spot. So, just be that word of advice.
Is it safe that now, so as we sit here now, the state is saying they're not going to play the jail calls or the texts in their case in chief. It's all dependent upon his testimony, which is, that in and of itself is helpful information. I just want to make sure that that's correct.
That's the plan. It's not a promise, but I understand what you're saying. We don't want to have a large disruption. So if there's one that I think could be objectionable, I'll keep that in mind and maybe raise it in advance.
I'm not going to micromanage your cases, but again, I've got a job to do too, and one of those is to make sure this case is done on time. And I don't want to waste time making rulings on evidence that could have easily been decided earlier. So.
And I appreciate there's a different analysis if he testifies, but I think that the law requires them to give us notice of which statements they intend to admit in their case in chief.